Okay, friends, we have a mistrial. Jury is at an impasse. This is breaking news. Prime Time with DutyRon is live.
Court is in session. Please be seated.
All right, Mr. Foreman, I am in receipt of your note. Judge Canoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All right, so the court, please.
Shocking details in the Karen Reed trial. A mistrial has been just declared by Judge Cannone. Shocking, unbelievable. I have no words at this time, folks. So the decision to have another trial will be made within a short period of time. I believe they have 30 or 60 days. So let's take a listen.
All right, I'd like to pick a status date to find out what our next move is. So I'd like to come back sometime maybe the end of July. I understand people have vacation schedules. Can we come in the week of the 21st?
That would put it at before 30 days, status hearing.
That's fine.
Miss Okeefe, John O'Keefe's mother, crying visibly in the courtroom. Just horrifying, folks. John O'Keefe's mom, visibly upset.
Could we do
members of the family.
22nd at 2 p.m., Your Honor?
July 22nd, 2 p.m.
I would appear for my client.
Right, is there another day that week? Could you do the 25th or 26th?
Unfortunately, I think I'm supposed to leave for vacation on the 25th.
Okay, the 22nd and the 24th are not great dates. So
What about
Shocking.
The 19th and 9th? Is that whole week?
no, that week's not good. Teaching that I cannot get out of.
Can we do August 7th, 8th, 9th? Any of those days?
No, we'll do the 22nd. We'll go back to the 22nd at 2. I can't let it go that long.
Your Honor, so the court knows Ms. Little and I are not available on the 22nd. We had a hearing in Los Angeles on the 22nd.
Okay.
We're proposing to appear remotely anyway.
Okay.
But for a status conference, I don't want the court to think it's disrespectful to the court, but Ms. Little and I probably will not.
Okay. So you and your client will be here in person, Ms. Yanetti.
Yes.
All right. All right. Thank you. We'll see you then.
All rise.
Shocking mistrial declared by Judge Cannone. Ed Wallace on location with us here. Ed, your thoughts? There's the Okeefe family. Now they're showing Karen Reed's father hugging his daughter in court. Ed, your thoughts?
Well, it's a shame they couldn't come to a verdict and get finality here. So now we have to wait and see what this prosecutor is going to do if they're going to try to proceed forward. I don't know how they could proceed forward knowing all the problems that surfaced during the trial, because now the defense attorney has more ammunition against the witnesses that testified, and definitely going to have a change of venue if they go at her again, because you can't have it in this town. Okay.
Yeah, and you heard the judge. She asked for an earlier date. She wanted to, have this hearing early. They agreed on the 22nd of this month, July 22nd at 2 p.m. Mr. Yanetti and his client, Karen Reed, have to be present for this status hearing. Again, we don't know what's going to happen. It's going to be up to the Commonwealth to decide if they want to go at this again. This is,
Now,
people
has the jury been officially dismissed?
they have been officially been dismissed, Ed.
Okay, now let's see who talks.
I'm gonna go back. I'll back it up so you guys can hear it again.
Yeah, let's see which one of the jurors talks and find out exactly what happened here.
Yeah. Okay.
Thank you. Be seated. Close the session.
All right, I'd like to pick a status date to find out what our next move is. So I'd like to come back.
I backed it up too far. Hold on. So basically, she just comes in and she declares a mistrial. Essentially.
What does she read the note from the
Judge
jurors?
Canoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that
All right,
to you
Mike.
folks. Your service is complete.
Ron?
I'm declaring a
Yeah.
Yeah,
So-
So, that makes perfect sense, right? These are jurors from this town, and the town is deeply divided as well. That's why this trial should have never been held in that town from the get-go.
Yeah. Well, now we're at a situation where I'm trying to look. I'm not trying to look at the feed here to see if there's anybody else that's live covering this outside. Give me a second here, Ed. Yeah. So this is as close as a win that the defense could get. The only other thing better for them would have been a not guilty verdict, right? So now their client is there's a mistrial, and they are at the mercy of what the Commonwealth decides to do going forward. And
Yeah,
we're gonna.
if
I
the
think we're gonna hear about it.
The Commonwealth is in a hole right now, okay? And you know what they say about when you dig yourself into a hole? Stop digging, okay? There's no way after this trial with these witnesses and all of this evidence stuff, because now they have a better game plan going forward on how to attack the evidence, how to attack these witnesses. And there's no way any reasonable prosecutor would go out this again.
Right. Yeah, I want to see what NBC Boston is. Oh, good. They've got it live. Let me go out to them. Hold on, Ed. I'm going to back it up just a little bit. All right, let's back this up here. Hold on.
So, we're going to have we have right in front of my other.
Hold on, Ed. I'm going to mute you for a second. What did I do with this? I just had NBC Boston. Okay, here we go. I muted you, Ed, because it was live. It was loud.
Okay.
But you're back. You're back. I just got to find that
Yeah,
feed that I just had.
I said I'm hoping I'm not making people dizzy by walking around Home Depot.
You're good. You're good. I just want to find that feed because they actually showed outside of the courthouse, and of course now I lost it. Oh, okay. Yeah, NBC Boston. So Ed, something that it seemed like this was going to happen when we saw on Friday. They said that there were an impasse and that they couldn't come to. And I wrote down the words. They basically said we are deeply divided. And you had mentioned
Yeah,
to
so
me. You had mentioned to me quickly. You were saying that you felt that it might have been one juror, but saying that deeply divided, that tells us a little bit something more. No.
yes, absolutely. So it wasn't a one or two holdouts. It appears that there may have been split.
Right. And a lot of people were saying that this was a slam dunk, and
That's where
and that's what we didn't have here. So let's take a listen again.
Establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please. Ms. Little and I are not available.
Using the Tui Rodriguez rule, it's also known as the dynamite charge, which has her strictly saying to them, please, there is no jury who can do a better job than you can. We need a verdict in this case. They came back then at 2:30, and the note says, despite rigorous efforts, our perspectives are firmly divided. And they went to go on to say some feel very strongly that there has been proof beyond a reasonable doubt. Others, the exact opposite, that there has not been proof beyond a reasonable doubt. This indicates that most likely it is more than just one juror who is the holdout in the division among these 12 jurors, 6 women, 6 men. And it says, since adherence to our convictions are deeply held beliefs, that this would not be worthwhile to continue to deliberate. This is after 9 weeks of testimony, more than 600 pieces of evidence, 29 days of testimony, and they spent about 5 days deliberating. The Commonwealth was charging Miss Reed with second-degree murder, motor vehicle manslaughter while driving under the influence, leaving the scene of a collision causing death. Manslaughter was also, as you see, motor vehicle manslaughter, but the lesser included charges were in there as well. The jury's instructions from the judge was that you can't argue with the law. It's not what you want it to be. It's what it is. The presumed innocence of Miss Reed, unless proven beyond a reasonable doubt. She doesn't have to explain herself or provide any evidence at all. That is up to the prosecution. And again, what it appears to be, and until we hear from the jurors or Judge Canoni herself, what it appears to be is that there was a deep division, more than one, within this jury of 12.
So there you have it, Ed. More than
Ron.
one, a deep division. Go ahead, Ed.
Yeah, I'm going to bail. I'll catch up with you later.
Okay, take care, Ed. Thanks for jumping in. All right, friends, just disturbing. I'm going to go to some coverage from outside the courthouse. They go on to show a little bit here, so I'm going to just play the rest of this for you.
Who could not come to an agreement as to her guilt or innocence. She went on to make sure that the must be unanimous under reasonable doubt doesn't mean proof beyond all possible doubt. You need to have moral certainty. If after looking at all the evidence, you do have reasonable doubt, then the defendant is entitled to the benefit of that doubt and must be acquitted. Still, despite all of that, they could not come to a conclusion. They had a half day of deliberations on Tuesday after closing arguments by both the prosecution and the defense. They deliberated Wednesday, let off a little early around 4. all day Thursday, all day Friday. Matter of fact, extending their deliberations until 4:30. Asked to think about it over the weekend. They came back and it did not take long. They were in there at 9 by 11:30. That was the first note to the judge that they just couldn't come to an agreement. And once again, around 2:30, once again, the judge got that same similar note that despite their rigorous efforts, their perspectives are firmly divided and that further deliberations will not budge one side or the other. Judge Canoni then declaring.
Does anybody in the chat feel amazed that they were deeply divided? That means there's 6 men, 6 women on this jury. Is anybody surprised by that? Again, the jury pool was picked from the surrounding areas of Canton, Massachusetts. I always call it when I'm wrong. I was wrong. I said that this would be a jury would come back with a verdict within hours, and Melanie Little actually agreed with me. And a lot of attorneys thought it would be a quick turnaround. And then as the days went on, day 1, day 2, day 3, now right up here until day 5, it just started looking bleaker and bleaker as we went on. But I just wanted to see how you guys feel in the chat. Do you feel that this is shocking that they were unable to come to a not guilty or guilty verdict? A hung jury, a mistrial. That's what we're looking at here.
A mistrial. On July 22nd, they will be back in court at 2 p.m. to figure out what is next. In terms of Karen Reed's lawyers, David Yanetti will be back with Karen Reed in the courtroom. And as for Mr. Jackson and Ms. Little, they're not available. They'll be out in LA. We have our courtroom insider, Sue O'Connell, on the phone. Sue, can you give me a feeling in that courtroom what it was like when it was officially declared a mistrial by Judge Canoni?
So before we listen to this courtroom insider, Mike says, will there be a retrial? That is not, it's unknown at this time. We do not know until the Commonwealth makes that decision. And they could either decide to retry her, or they could say, oh, we're not going to retry her. And then she walks, and then that's it. So we'll have to see. We'll have to see what's going to happen, and we'll find out more on July 22nd at 2 p.m.
JC, I think you could pretty much feel the relief of the jurors when the judge declared this mistrial. There's been one juror who has been crying on a regular basis when she goes into the courtroom.
Sue, we're gonna cut in and listen to Alan Jackson. Hold one moment.
Okay, here's attorney Alan Jackson on the steps.
All right, we can't seem to hear it. We are recording this right now. Of course, we'll get it to you. Sue, continue to talk to me about the relief that you say the jurors felt. Or at least
I mean, they have been a pretty poker-faced looking crowd all through. I mean, occasionally, as we've been reporting on Canton Confidential, we see faces, they make motions, and we can only, guess what we think that is based on our human experience. But today, they actually came in looking bleary-eyed, looking like they had the weight of the world on their shoulders. And when they came in this afternoon, there was absolutely no doubt about it that they had tried as hard as they could. Everyone in the courthouse, all the people that I have talked to, have talked about how...
That was a great question posed by our good friend Wild Z Pony. Eileen asks, can the jury now talk to the public? Absolutely. They're dismissed. We can hear from the jury. And I would say that don't expect to hear. I'm sure that they're going to want a little bit of privacy, but you never know. But yes, they can now talk freely to the public because they are dismissed of their civic duty. The trial is over. It's a mistrial.
Hard this jury has worked, and that there should be in no way, shape, or form any look at that they didn't complete the task that was given to them for whatever reason. Obviously, we will learn more about what went on in the jury room when we find out who the jurors were and if some of them would like to talk to us. But there was a feeling of relief. And also, some jurors looked really pained when they were walking out. Certainly, again, we don't know what the issue was. We don't know how many people are split. But they walked out feeling, I think, by looking at them, that they had worked really hard, and some of them were pained and looked disappointed that they didn't get to the conclusion that they were hoping for, JC.
Sue, what about the Okeefe family? I could see Mrs. Okeefe in the background. She's been emotional, but not overly so. I imagine that she saw this coming, as we all sort of did, based on the note that was sent to the judge on Friday and then again this morning. But did you get any sense from the Okeefe family what this verdict meant to them?
I saw them when they walked into the courtroom, JC. I didn't get to see their faces when the judge declared the mistrial or basically said that the jurors were stuck and they weren't going to go further, and then declared a mistrial. But, you know, coming in, you can just imagine the trudging in back and forth, waiting to see if there's going to be the answer that you hope for. They did look like that this has been really just wearing them down. You could probably hear the cheers in the distance of the Karen Reed supporters, but all in all, this has been just very difficult for them, and you could tell by the weight of the world has been on their shoulders as well. I talked to a number of law enforcement outside today, and they were just saying that regardless of the verdict, the fact that they're not going to get any sort of closure or idea of what might have happened to John Okeefe is really part of the great tragedy here. And as we have tried to keep doing, keeping the idea and that John Okeefe is the victim here. He died tragically, and at this moment, we're not going to know.
It is over, little Patty. The trial is over. Mistrial declared, and it's up to the Commonwealth to decide if they are going to go after again have another trial for this case. Will it be a change of venue? I would imagine so, but one never knows until it happens. But essentially, the Commonwealth versus Karen Reed, second-degree murder, motor vehicle manslaughter while driving under the influence, leaving the scene of a collision and causing a death. They were unable to come to an unanimous verdict at a deadlock. Mistrial declared by Judge Canone.
Why, and at this moment, no one is being held accountable, JC.
Sue, stay right there. We have Michael Coyne, our legal expert, on the phone. Michael, Judge Canoni did say that they would reconvene July 22nd at 2 p.m. to figure out what comes next. So you tell us what comes next in something like this.
All right. And before he answers that, somebody asked if Karen Reed is free. Rachel L., thank you for the question. She says, DutyRon, is Karen free? Is she still technically on bond? She is still technically on bond. She is not free. She is going to be back in court with Mr. Yanetti, her attorney, on July 22nd at 2 p.m. for a status hearing. And it's going to be up to the Commonwealth to make the next move, whether they will retry this case. And I don't know under Massachusetts state law how long that they have to make that decision. But some say it's 30, some say it's 60 days. But excellent question, Rachel L. Thank you for that question. And thank you for everyone being here. If you can, please hit the thumbs up and subscribe if you're new. And thank you to the moderators and everyone who is here in the chat. Let's hear what this legal analyst says about what's the next move. And that's the question that the reporter asked this law analyst. What's the next move? Let's listen.
Well, the prosecution will have to decide whether they want to retry her or not, and I expect that they will decide to retry her. It's the death of a police officer, and the prosecution feels strongly that their case is correct, that they've got the right defendant. And so then the question becomes, will the defense attorneys be able to come back? Can they fit it into their schedule? The financial issue becomes a question as well. And then ultimately, how do their schedules all work as to when this might be retried? There's always the possibility that the government might decide not to pursue a second trial. I don't think that's likely. There's also an unlikely possibility that they could strike a deal as well. Again, I think that's an unlikely possibility here, JC.
Let me just ask you, how much say does the Okeefe family have when it comes to the prosecution's decision whether or not to retry?
Not a lot. I think obviously the district attorney would take into account their feelings, but either whether they were strongly one way or the other wouldn't necessarily be dispositive. As the chief law enforcement officer for Norfolk County, he has a responsibility to everyone involved to really take a hard look at the case and see whether it makes sense to go forward again.
All right, Michael, joining me now on the set is Glenn Jones. Glenn, as you heard, that has been declared officially a mistrial, which is where we were leading based on the jury's note to Judge Canoni on Friday.
And for anybody who's confused of why Karen Reed went right to her father and hugged him in like almost like a victory hug, because this is the next best thing to a not guilty verdict. They a hung jury, a mistrial. The chances, she has a chance that they do not choose to retry this case. I don't think that they will not retry it. I feel that they will, but that's just my feelings. It's up to them to make that decision. But so her hugging her father, her attorneys shaking hands with each other and shaking hands with the family, this is the next best thing to a not guilty verdict, in my opinion. You let me know what you think in the comments section.
Friday late in the day, and then this morning, and then here we are, 2:30, they came in and declared yes.
I suppose at this point we can't be entirely surprised that this is where things ended, especially with how eloquent and articulate the notes were from the jury. And here we go. I expect, as Michael Coyne just said, that we'll be here doing this again, because of course there is a victim in this case and there's no accountability yet for his death.
Michael, are you still with us on the phone? Michael,
I am, JC.
I just wanted to ask you, and this is a Monday morning quarterback kind of question, but it's also just off the top of your head. This was a 9-week trial with more than 70 plus witnesses. If this were to be retried, could we think that the prosecution might have the ability to cut that in half and perhaps take a slightly different approach to this?
I think you're absolutely right. If it's tried again, they have to cut it in half. They have to boil it down to the essential parts of the case as they see it, which should be the excessive drinking, the driving, and then obviously tying his death more closely to her actions than they did in this case, in all likelihood. The fact is that the jury must have struggled with some of these issues. And so the government gets a chance to have a do-over here and fix the mistakes they made. To me, this is a win for the government simply because the defendant's resources were likely drained at this point. Most of us thought that this would likely be a not guilty verdict. So to have the chance to correct the mistakes that we saw during the first trial, this is, if they're going to retry her, they all, in almost all likelihood, will have a significantly different case that will be mightily pared down from the last case.
Okay, Michael, thank you. Stay with us. Let's go now to Denham and NBC 10 courtroom insider Sue O'Connell braving the weather conditions there for us, Sue. We've been talking on Canton Confidential about the likelihood that this jury had to wade through so much evidence. And of course, that is still true. But I wonder, Sue, what you think was happening in that jury room now that we know that people were kind of dug in on their personal beliefs and the rhetorical arguments that must have been ensuing inside that jury room.
Right. What we heard, Glenn, from the jurors' note, right, was that it wasn't about the evidence. It was a different interpretation of the evidence. It was, if I remember what they said correctly, that some felt it met the burden of proof and some said that it left too much reasonable doubt. And we had heard earlier I think the note from this morning from the jury that there was a deeply held convictions, or there were deeply held convictions, that it wasn't that they hadn't worked hard enough. It wasn't that they hadn't evaluated the evidence. It wasn't that they hadn't thought hard about this. That 1, 2, we don't know how many jurors had come down to a decision that the other jurors disagreed with, and there was no moving them. So some immediate questions I have about that was that if there is indeed some deeply held conviction, and remember, we don't know if they were disagreeing about charges, the lesser charges, we don't know if they were disagreeing about guilty or not guilty, we don't know what the numbers are in the split. But, and I also think that the foreman was also being somewhat diplomatic by the way that the letters were written, the notes were written. We can't intuit what the numbers are there. So having said that, saying someone has, or some jurors have, a deeply held conviction, I'm wondering if that was something that maybe should have been vetted out during the voir dire of the witnesses. For example,
I'm a commentator, so I can tell you this. I'm against the death penalty. So I would be unable to serve on a jury if death penalty was on the table. That's fine. That's the law of the land, but I would be vetted out of that. So I'm curious to find out what this strongly held conviction is that one or more jurors have. And I'm also just really very curious to find out if it breaks down between a not guilty versus guilty, or if there were some of the lesser charges that really broke it up. Glenn and JC.
All right, Sue, thank you very much. Now we want to just go
Some
out
good
to
points
what
there.
the defense had to say when they walked out of court. Sue, take a listen in, as well as our viewers.
Okay, here comes the defense statement outside the court.
Judge Canoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case.
Folks, this is what it looks like when you bring false charges against an innocent person. The Commonwealth did their worst. They brought the weight of the state based on spurious charges, based on compromised investigation and investigators and compromised witnesses. This is what it looks like. And guess what? They failed. They failed miserably, and they'll continue to fail. No matter how long it takes, no matter how long they keep trying, we will not stop fighting. We have no quit. Go ahead.
I just have two things to say, folks. Number one, I am in awe of the strength and courage of this remarkable client that I've had the privilege of representing since day one. And number two, I want to send a message to all of her supporters out there. Your support was invaluable. We are touched, and we ask for your continued support. I'm not from Texas, like my colleague here. I'm a Boston kid. But I'll repeat what he said, which is, we ain't got no quit.
There you were hearing from the
There you have it.
team, both David Yanetti and Alan Jackson, which, by the way, Alan Jackson is based out of Los Angeles. Whether or not he will continue on the case, there was a reporter who yelled that out. We don't know, but we just did get this press release in from the district attorney's office that did say, we thank the Okeefe family for their commitment and dedication to this long process. They maintain sight of the true core of this case to find justice for John Okeefe. And Glenn, of course, the most important line is the last one. The Commonwealth intends to retry this case.
So that statement is significant for two.
That's a significant statement because the Commonwealth just stated in a news press release that they do intend on retrying Karen Reed. So there's your confirmation, ladies and gentlemen. We were just talking about it earlier. We were saying we don't know. It's going to be July 22nd. But the Commonwealth just put on paper that they will be trying Karen Reed again. So you just heard it here on Boston 10. So let's take a listen in again.
Two reasons, JC. Of course, the last point that you made, they intend to retry this case. They believe they have a winnable case. But the second is, we haven't heard from the state since this trial began because they stay quiet during the process of the trial. Now that the trial is over, we're hearing from them, and they at minimum have enough confidence to try this case again.
We will see how they will do it again. Judge Canoni has July 22nd down. So we really have to wait, at least 3 weeks, a little over 3 weeks until 2 o'clock at that day to decide to hear from both sides. She didn't want to wait any longer than that. Yanetti, the defense attorney, was trying to push it possibly into August, and Judge Canoni said, no, we're doing this sooner rather than later. Kirsten Glavin has been following this trial for us all along. Kirsten, how have things been outside the courtroom after this announcement?
JC, as soon as the announcement came down that this was in fact a mistrial, we did hear a round of applause, but also a lot of different emotions from people in the Free Karen Read movement. A lot of people had been anticipating this as the outcome of this trial, but obviously it wasn't what everybody wanted. Now, I am here with Paul Cristoforo, who has been organizing a lot of the Free Karen Read movement throughout all of this. What is your initial reaction right now?
My initial reaction was there wasn't a guilty sentence in there. Out of the 12 people that were in there, they couldn't find enough people to find her guilty. And it was a mistrial, not because of illegal fraud, not because they couldn't convince 12 people that Canton Reed is guilty.
Is that for you, or is this what you expected? What's going through your mind?
My initial expectation was automatic, not guilty. But as we learned this case, nothing happens the way it's supposed to happen. So am I satisfied with it? Not with the mistrial right now? Yes. But do I want more? Absolutely.
Now, what are you looking forward to moving forward? Where do things go for your movement from here? I know a lot of people have been saying they're going to stand by Karen no matter what happens.
Yeah. As far as our movement goes, we are going to stand by Karen. We do have some more work to do. We learned a lot of stuff that happened during this trial within the Mass State
Investigation going on.
Who's also covering reaction.
Would have in the courtroom, elected office, that Morrissey could in fact be elected out of the office. So the deeper part of the reaction of the
Only serve to force us to compromise the
Have to wait, what, at least 3.
Where do things go for your movement from here? I know a lot of people have been saying they're going to stand by Karen no matter what happens.
Yeah.
A reasonable doubt.
All right. The reason I put it back is I want you guys to hear Yanetti and Jackson on the stand on the steps outside the courthouse. I want to replay that, and also breaking news, as we just heard, the prosecutor in this case stated that the Commonwealth will retry Canton Reed. And again, everybody that's here that knows Ed and I, our opinions on this is that the Commonwealth did not prove their case. They did not prove beyond a reasonable doubt that Canton Reed did in fact murder John Okeefe, police officer John Okeefe. Now, what we always want is justice for the victim here, the victim and his family. As we saw, Mrs. Okeefe, John O'Keefe's brother, the rest of the family, his father, all of them in and out of court, they need to have answers. They need answers into what and who is responsible for the murder of their son, the murder of their brother, the murder of their family member. And that's what this is about. And again, they're going to go back at it, and it's going to be in a retrial. They're going to retry Karen Reed. That's as per the Commonwealth today in a press brief.
Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case.
Folks, this is what it looks like when you bring false charges against an innocent person. The Commonwealth did their worst. They brought the weight of the state based on spurious charges, based on compromised investigation and investigators and compromised witnesses. This is what it looks like. And guess what? They failed. They failed miserably, and they'll continue to fail. No matter how long it takes, no matter how long they keep trying, we will not stop fighting. We have no quit. Go ahead.
I just have two things to say, folks. Number one, I am in awe of the strength and courage of this remarkable client that I've had the privilege of representing since day one. And number two, I want to send a message to all of her supporters out there. Your support was invaluable. We are touched, and we ask for your continued support. I'm not from Texas like my colleague here. I'm a Boston kid, but I'll repeat what he said, which is we ain't got no quit.
There you were hearing from the defense team, both David Yanetti and Alan Jackson, which, by the way, Alan Jackson is based out of Los Angeles. Whether or not he will continue on the case, there was a reporter who yelled that out. We don't know, but we just did get this press release in from the district attorney's office that did say, we thank the Okeefe family for their commitment and dedication to this long process. They maintain sight of the true core of this case to find justice for John Okeefe. And Glenn, of course, the most important line is the last one. The Commonwealth intends to retry this case.
So that's state.
Again, as you heard loud and clear there, the Commonwealth intends to retry this case, and they have the option to retry the case. And that's exactly what they said they were going to do here. Forbidden says in all capital letters, if she's guilty, then she would have been convicted. But guess what? She wasn't. So, ... Thank you for that. And listen, everybody has their own thoughts and opinions on this. It's going to be about what the Commonwealth decides to do, and we just heard what their decision is.
Statement is significant for two reasons, JC. Of course, the last point that you made, they intend to retry this case. They believe they have a winnable case. But the second is, we haven't heard from the state since this trial began because they stay quiet during the process of the trial. Now that
For the meantime, just to, for the
They intend to bring charges against someone, they should. And if whatever, there should be more sunlight there as well so that we are able to see what the results of that investigation has revealed. Because it has brought a real problem and an atmosphere to this case that has made it difficult, I think, for both the defendant and the prosecution to be able to try their case completely effectively. May well have contributed to the deadlock that we have here.
Okay, Michael, thank you. In a moment, we'll ask you about finding an impartial jury for this retried case because that could be a challenge. We'll find out, I'm sure. Let's go to NBC 10's Mary Marcos, who's also covering reaction to this mistrial ruling from Judge Beverly Canoni. Mary, what are you hearing?
Well, Glenn, when that ruling came down, the crowd erupted in cheers. The police have now blocked off much of the road here. We can't really get much further down than that because they are trying to protect the identity of the jurors who are now being sent home. Legal experts telling me that the prosecution will now have to make a decision, and we've heard from the statement from the DA's office, they do intend to retry Karen Read, but legal experts told me that they expected to hear that. Whether or not they will actually retry Karen Read, they had mixed opinions on. Either way, they will have to do that within a year from today. That's Massachusetts state law that they have to do that within a year. Within the Manuel Lopes case where we saw with police officer Michael Chesna out of Weymouth, that happened within about 6 months. So either way, we will be seeing more of this within the next coming months, and we will be hearing possibly from the jury.
Okay, so that's pretty huge. The Commonwealth has up to a year. So July 1st of 2025, they could retry Karen Read anytime leading up to, but not after July 1st of 2025. So they could potentially start the trial on July 1st, 2025, as long as it commences before the end of that year time. So that is as per Boston law, they've already made their intention known that they intend to retry Karen Read, but they do have up to a year to prepare and start this trial.
Jurors themselves, legal experts say they couldn't decide to come forward with what happened in that courtroom. What were the discussions? Where did they get hung up? So we could hear from them. We'll have a lot more to dig into in this. For now, we're live in Dedham. Mary Marcos, NBC 10 Boston.
Hey, Mary, before you run, I just want to ask, we know there's been a 200-foot buffer zone around the courthouse throughout this trial. Are you saying that that has been expanded now in order to protect jurors?
I would say that that's probably more than 200 feet where the police are keeping us away from that. So I guess perhaps it has expanded quite a bit for the meantime, just to protect the jurors' identity as they try to leave the courthouse.
Okay, understood. Mary Marcos, thank you.
Let's go out to our Sue O'Connell, who's been in the courtroom every day of this 9
The
weeks.
jury wasn't
Sue,
polled.
did you have any chance to see Karen Reed?
Stand by, folks. The jury wasn't polled, but I do not think that that it is necessary, because if it was legally necessary to poll the jury, I believe that it would have been done. This is a mistrial. It's not that there was a verdict here. They were not able to come to a decision. So the judge, if it was legally necessary, if that was one of the legal steps, it would have been done, and it wasn't done here, folks.
Karen Reed's family as they walked out and perhaps get a sense of their mood?
I didn't, JC, because I was over here on the phone with you at the time. But I'll tell you that you could tell by Karen Reed's face when the mistrial was declared by Judge Beverly Canoni. There was not a big smile, but there was definitely a look of relief. We could tell over the days that this trial is coming on, she was looking more stressed. People have certainly been commenting about her demeanor in the courtroom and how it was being.
That's a good question. Somebody just asked. Will it be the same judge? It can be. It can be. I've seen cases that have ended in mistrials in New York. The same judge, the same prosecutor, and the same, basically the same witnesses. The trial that I will reference is the trial that involves the jogger who was murdered and raped in Queens County in New York in, I believe, 2018 or 2019. Karina Vetrano, she was the defendant was a trial commenced. It was declared a mistrial. They could not come to an unanimous decision. The same prosecutor, the same judge retried the case. So yes, it could be the same judge and the same prosecutor.
Some thought and said it was disrespectful to the Okeefe family and to the death of John Okeefe. But over the past few days, it has definitely been tightening up and getting more stressed. And her family as well, her parents also looking more and more put upon and more burdened as this trial was going on. So when that happened, you know, it's an odd thing, right? The judge declares a mistrial. This is the thing we have been waiting for, both. And then they immediately go to sort of administrative business that they have to do. So there's no moment of release or relief or celebration or mourning or whatever emotion you would have in the courtroom. You then have to sit and listen to David Yanetti, the lawyer for the defense, talk about what week his vacation is. And Judge Beverly Canoni is teaching that week. And Andrew and Alan Jackson and Eliza Little are unavailable and will be attending by Zoom. So there's this big moment. Get our calendars out. So the feeling within the courtroom did still feel very still and very tight. But when they came out, you could see them on the steps. The Reed family, Karen Reed and her defense attorneys, definitely still full of fight. I think anticipating that another trial was going to come and setting the tone for that.
Sue, when you're not our courtroom insider, you're our political commentator. So let me ask you about the political calculus that goes into Michael Morrissey's decision to retry this case. Of course, he's an elected official, and I would imagine that the next election must be in his mind when he's making this decision.
I'll tell you, Glenn, that one of the things that I have heard from people all up and down the street, and because it's mostly Karen Reed supporters, very few people for a counter protest or supporting the Okeefe family have been outside. So I just want to say that up front. It's mostly Karen Reed supporters I have talked to. Many of them were learning for the first time how our justice system works, and that it's the district attorney and it's the district attorney's office and how important district attorneys are. We know in Suffolk County, and across parts of the urban areas of Massachusetts, the ACLU had run a program a few years ago called "What a Difference a DA Makes." And that was in regard to responding to Black Lives Matter concerns about how overcharged Black and brown people are within the Commonwealth. So for many of these people, for the first time, they were understanding that that's an elected office, that Morrissey could in fact be elected out of the office. So the deeper part of the reaction of the what I have sometimes called circus atmosphere out here, the cheering of Karen, the lack of concern or expression for John Okeefe and John Okeefe's family, I think also may turn into an awareness of political power for this group, especially when it comes to his running for re-election at some point and the things that have to happen. And I've been spending a lot of time with new friends and colleagues who are working covering this from Canton Public Access Television and talking about the splits that are happening within Canton regarding their concerns about the concerns. Right now, Paul Okeefe, John Okeefe, Okeefe's mother is coming down, and they have been obviously through this trial every single day some sort of justice.
Just want you to know that's on their end.
Obviously, you don't need to.
I'm just going to pause it for a second. This is the news feed from Boston 10 NBC. Looks like they're having a problem with their upload link, so it's not on my end. I can't fix it. That's what it is. What it is.
That they are heavy. They have also been through an enormous amount of.
This is the Okeefe family.
All right, Sue, thank you. We're gonna, the shot is breaking up a little bit, so we will come back to you, but I appreciate the fact that you're remembering John Okeefe and all of this and the Okeefe family, and where really thoughts should be with is the man who lost his life at a mere 46 years old on that day. We want to bring in our legal analyst one more time, Michael Coyne.
Amen.
Michael, there is no question this is a high-profile case. We know when
I want to give kudos to this Boston 10 for reporting on both sides. I mean, you know, they're showing both sides of this, and the bottom line is that the truth of the matter is this family, the Okeefe family, is leaving that courthouse not knowing and confused probably. So it is a shame, and unless you have been in that position, or God forbid, I don't wish that on my worst enemy, you don't want to be in that position. So my heart goes out to them, irregardless of all the facts of everything. The bottom line is they lost their son, they lost a loved one, and they don't have any answers. So put yourself in their shoes and take a minute to think about that.
Cover it through our Canton Confidential, the Karen Read murder trial newscast at 7 o'clock, through our podcast that we have viewers now coming from across the country, in some cases across the world. If within a year they need to seat another jury of at least 12 people, how do they do that in a way where they do not already have an opinion about this case? Because every day Judge Canoni started with the same 3 questions. Did you hear anything? Did you see anything? Let us know if you have outside influences on the case. What do you say to that?
Well, it's going to be a challenge. There's no doubt about it. You're not entitled to a jury that knows nothing about the case and hasn't been exposed to anything. What you are entitled to have is a jury that is, despite what they know, despite what they've heard, is willing to rule only on the evidence submitted at trial. And it will be a challenge because of the widespread publicity this case has and its polarizing nature, to find jurors who will be able to put aside whatever they have already heard and decide it solely on the evidence. But, you know, around here, we've tried a lot of high-profile cases, whether it's Whitey Bulger or Aaron Hernandez or the Marathon Bomber. And the judges will have to take special pains, because even in the Marathon bombing case now, the appeals court has sent that case back to the trial court to take another look at whether a couple of the jurors were influenced by social media and involved on social media. So it is a painstaking task that the court will have to take great effort to get it right. But hopefully they will be able to get it right. Even with all the publicity this case already had, obviously we had a jury that took their oath seriously. It's very difficult to stand in judgment of someone else, and it's a significant responsibility, but we were able to do it once. They'll have to try and do it again, and hopefully they'll have a jury that will be able to come to a unanimous decision next time.
The publicity that you and JC were just talking about, Michael, is really just one way in which this trial was so unusual When you look back on this, what will you remember as being so atypical of all the trials that you've seen in the past? Of course, we had the courtroom change because of jury sightlines. We've had
weak points or not are. And again, we don't know, and they're under no obligation to talk, but usually somebody winds up talking, at least to the reporters. And I'm really curious, were there like 10 people for acquittal or 10 people for finding guilty, or were they evenly divided? And I think that may give us a bit of a roadmap if we can actually find out what they did, and then see, if I was defense counsel, I'd want to say, oh, this is where I could have been done better, or not.
No, that's a good point. I think all of us would like to hear from people who were in that room, JC. That would give us so much insight.
Of course, that will be up to each individual juror. Thank you, Peter Ellikin. We want to go out to Mary Marcos. Mary, I know it's raining outside. However, how many people are still milling around? Because a big part of the draw of this case has been people wanting to talk to other people about their thoughts, people coming together to, whether it's debate or to unite on one side or the other. What's happening around you?
Well, right now, JC, a lot of the crowd has dispersed. My photographer can kind of give you a pan to look around, but you can see that there's still a lot of news crews obviously out here. The barricades remain up, and the traffic is actually now moving freely again. They had closed down the roads for a bit as the news rang out, and people were cheering right on the sides of the streets. And that crowd has pretty much dispersed at this point. We did see a bus, presumably carrying some jurors, drive off from the back of the courthouse. Again, state police have been very adamant about protecting their identities, because if and when they do decide to speak out, that is a danger to them. Legal experts tell me that, this has been such a divisive case. People have taken both sides, and that speaking out for a juror could be dangerous. It could mean threats. It could mean, we do see a lot of those threats on social media as well. So that is a danger to them if they do decide potentially to speak out. But of course, everyone is wondering what happened, what was being said in those four walls while they were deliberating, and we hope to learn that at some point. And in the meantime, we will continue digging into the next steps, as you've heard our legal experts speak to in this case.
Oregon.
Yeah, Glenn, I just want to take a moment to acknowledge the great staff at the courthouse, both inside and outside. If you're following along on social media, you know there was some mishigas in the line with the press, and some people were very well behaved. But all along, the folks that worked inside the courthouse worked really hard to make sure we got as much access as we can. The court officers were polite and friendly and gave us as much information as they can. So, and the state police outside, both trying to enforce the buffer zone and allowing people to, just live their lives. And the people of this Dedham neighborhood who have been putting up with this for quite a while there's one dog that I've been watching, this woman and her dog walk 3 times a day. The dog has been disturbed because this hasn't been his usual route. But we've just been imposing, it's justice, it's what's happened, it's our justice system, but we've been imposing on the neighborhood. And I just wanted to give a shout out to the court staff, because they have been exceptional here on the ground with us, and wanted to take a moment because it looks like if we have to do it all over again, we'll be with them again, Glenn.
Okay, Sue, thank you. We appreciate all of your coverage of this trial, which started, JC, on April 29th. And here we are on July.
All right, friends. So that's been the coverage. Karen Reed trial, mistrial declared. They have up to a year. They have until July 1st, 2025 to start this trial back up again. Will it be back in Canton? I don't think so. Will it be the same prosecutor and judge? Maybe. I've seen it before. It's not like it hasn't happened. Same exact prosecutor, same exact judge, maybe in a different location. We don't know. But Karen Reed, as of now, mistrial declared, and the Commonwealth has said in a statement that they will retry Karen Reed on this case. So we'll see what happens. I thank you all for being here. I appreciate you all coming in and leaving your comments. I know it's a very heated argument, a heated conversation, but again, it doesn't get us anywhere with arguing. We can all agree to disagree. There are some people who feel that Karen Reed is innocent. There are some people that feel she is guilty. And you have to respect those people. And that's the only way that I operate And I've expressed my feelings to you guys. I feel like the Commonwealth did not prove beyond a reasonable doubt. Ed Wallace feels the same way. But if they did, then we would be saying a different thing to you. If they did prove beyond a reasonable doubt, we would be saying that we felt that Karen Reed is guilty of this crime. But they did not do that. They have the burden, and they did not meet it in this case. And the verdict, the jury spoke without being able to come to a verdict. I'll see you on the next one. Thank you for joining. God bless, and I will talk to you soon. Thank you.